Well, I'd like to welcome all of you that are on our webinar today to the subject that is near and dear to my heart and near and dear to all of our hearts, and that is we're all building our own practice, or we have built our own practice, and we've accumulated assets and we've accumulated clients, and we'd like to keep our practice shielded from any litigation. So that's what we're going to be talking about today. And not only are we going to be talking about it, for the second time ever, we have a special guest. The special guest is David Rao, and he's the Chief Operating Officer and General Counsel of Annexus. But I do want to point out that David, and I'd like to have you come on. You've spent most of your career not as a Chief Operating Officer, but someone who was prosecuting and defending litigation or lawsuits, correct?
True, Rex. Years at a large private law firm here in Phoenix before joining Annexus about 2.5 years ago, and primarily doing business litigation. And at a big firm, you primarily find yourself on the defense side. So that was 20 years, and then have enjoyed being here for 2.5.
Right. And so everyone can read all of the kudos that David has. On the left side, I think the best one is that your mom thinks you're the best lawyer ever. So
took me a long time to get that endorsement.
I'll tell you, if that was not there, I would probably question your ability. But I'll tell you that is means a lot to me anyway. At the end of the webinar today, David has agreed to answer questions. So you go ahead and type in a question in the chat box. Include your city, so we can say David from Omaha or Sally from Atlanta, etc. Ask this question. That would be really kind of you. Before we start, I want to talk about the Annexus Research Institute. It's the educational arm of the Annexus Group, and we talk about all the things that the Annexus Research Institute is. I'd just like to mention the webinars. If you're new to the webinar, and we have one of the largest sign-ups today that we've ever had for webinars, so this topic is very relevant. We try and do 10 webinars a year. We don't do webinars in December because of the holidays, and we don't do webinars in August because most everyone's on vacation. Other than that, we try and do a webinar pretty much every month. So, and this is one of them. This is our last webinar of the year. So we're going to be talking about the growing need for asset protection as lawsuits skyrocket. There's more and more lawsuits happening. I mentioned this to David when we did a run-through. I take Investment News magazine, and it's a weekly magazine that comes through, and almost every week there is someone in there that is being sued, and they have a story on why they're being sued and what the consequences are. E&O insurance is often not enough to protect your personal assets, so if you're relying just on your E&O insurance to protect you, that might not be enough in case you are sued, and even if it does cover, there can be some catastrophic consequences. Whoops, I'm going to go back up on that one here, Brian. Well, I guess I aren't. You're going to have to find out what the other 2 points are. How am I doing, David? Are you impressed so far?
You're doing great.
Okay. For attending today's webinar and filling out our brief survey that follows, you'll receive Social Security Strategy number 10. By the way, this strategy, and we hope you're collecting all of our strategies as we do these webinars, this strategy, number 10, during all of my trainings, this strategy is the one that is best received. So this is one you'd really want, Social Security Strategy number 10. We have 15 strategies. I have all the strategies done. We're going to keep releasing the strategies until we get all 15 out to our seminar attendees. Brian will send you the URL toward the end of the webinar through the GoToMeeting box so you can have this. So one poll question today, very easy. and like to have everyone participate. There's quite a crew out here. Have you ever been afraid that a client might sue you, had a client threaten to sue you, or actually had a client sue you? So I really could have just said, have you ever been afraid that a client may sue? Because if you had a client threaten you, you'd be afraid, or if you actually had a client, you would. But we're not saying that you have been sued, but have you ever been afraid that a client might sue you? Brian, let's go ahead and open up the poll and see how everyone's answering this, okay? Okay, boy, everyone's really doing really well and jumping on. Okay, Brian, we're there now. Wow, that is interesting. I thought it'd be a little bit higher than this. Go ahead and close her down and see where we are. 52% said yes, I have been afraid of being sued, and actually 48% said no. So I thought it would be a little bit higher than that. That's pretty interesting. But still, over half of everyone on the webinar today have at some time at least been afraid that a client may actually bring litigation against them. I want to start talking about my first incentive trip. It was to Hawaii. You know, most guys can tell you what their first car is. I am told that most girls can remember their first date, but also in our business, generally, that first incentive trip really sticks in your mind. The first one you ever got to go to. I've had the privilege of going on quite a number of incentive trips, both as an advisor and also as part of home office staff. I spoke at some of these as well. But I remember the Hawaii trip, and we went to Maui. And I remember during the meeting on that incentive trip, we had a business meeting. And during the meeting, one of the old timers or older people in the group stood up and was talking about litigation, and he said this: I would like to have everyone here who has never been sued stand up. And so I very proudly stood up with a number of other people, and I was so proud that I hadn't been sued, and the rest of the people that were sitting down had been sued. And he said, look around, ladies and gentlemen, these are the people who have not been in the industry long enough to be sued yet. And then I was a little embarrassed as I sat down. When the co-owner of our company, Don Dady, heard that we were doing this webinar today, he mentioned to me that when he first got into business, he worked for American Express. And at American Express, they said to him this: there are only two types of advisors in our business: those who have been sued and those who haven't been sued yet. So what they're trying to get across to him is you need to work with every client and make sure you're dotting your I's and crossing the T's, because this may be the one that actually ends up litigating against you. Well, a few years later, I was in my office and got a registered letter in the mail, and it was 1986. I had a client get into a tax shelter, high write-off tax shelter, 250% write-off. And as a result of that tax shelter, Tip O'Neill and Ronald Reagan got together and they changed the tax laws, and that tax shelter wasn't any good anymore. Well, I couldn't understand why in the world he was litigating, because he put in $15,000, he got more than 50, or got $15,000 actually, as a tax refund from going into the tax shelter. That's why he went in. So I couldn't understand why in the world he was suing, and he was suing because he said he did not understand that the tax laws could change, and he didn't really understand the tax consequences of the program. And by the way, this individual's profession was he was a CPA. So we had I went before what's it called when you go and
Deposition.
deposition? Man, that jumped right out of my head. We had our depositions, and my attorney called the E&O company, and the E&O company said, talked to him, and he says, what's the chances of winning? And my attorney said, there's obviously not a 100% chance of anything, but I think this is one of the best cases we've ever had. I think we're going to win. So I was ready to go fight this. And the E&O company said to the attorney, how much would it cost to litigate this? And the attorney said, in my estimation, $12,000. And they said, settle for $12,000. And so it was settled for $12,000. But here's the kicker. It went on my U4 form. It has been part of my securities record for the last 30 years now. And theoretically, I didn't do anything wrong. So the first point I want to make is oftentimes we feel we're right. We may be right, but there's that chance of settlement there, and it's usually for attorney fees. And since you've been a part of this for quite a while, David, can you explain why that happens?
Yeah, let me first comment on the $12,000. 30 years ago, because at my firm we couldn't open a file for $12,000, so you had an affordable attorney. But it's just a business decision. So if there's 1% risk, and I can eliminate that 1% risk, or usually it's 5 or 10 or 15 or 20% risk, for the same amount that it's going to cost me to fight it and spend my time fighting it, and they're going to have their underwriters and their agents looking at that case and spending time. So if I can eliminate all that risk and all that time for the same amount of money, I'm going to do it. And let's talk back to talking about E&O, though, about whether or not you as the insured person have the right to veto that settlement, because there may come a time, and that case may be a good example of when you as the covered person don't want to settle it. You'd rather take on that 1% risk, to keep it off your record, to keep your reputation the way that you want to. So that's something that everybody should be considering when they're looking at their E&O coverage.
They offered that to me too, David, how well I remember. And the only problem was if they didn't settle, then I was on my own dime at that time, and I didn't want to do that.
All of a sudden that 1% risk, yeah, that 1% risk looks really big.
Yeah. So let's take a look and see what the problem is. And we have some cases here, and David's going to make some comments on it. This is kind of high profile. I'm going to start with some high profile cases here. $12 million is what they were asking for in this case. And the reason I'm bringing this up quickly is oftentimes we have $1 million E&O coverage, and the next thing you know, you're being sued for far more than $1 million. So, and that happens. They can sue for anything that they want. By the way, the CPA, when he sued me, remember he had $15,000 invested. He sued me for $180,000. So, go figure. Here's one that's kind of interesting, and I want you to comment on this one. This best-selling crime writer actually won $51 million award. That's huge, but let's look and see what else is here, and this is what I want you to talk about, because a lot of states have this, and it could be worse than the $51,000. A judge is expected to rule on a whole different set of charges, that the firm violated consumer protections, which could as much as triple the damages. Could you talk about this triple the damage situation here?
Yeah, after you spend 3 years in law school and $200,000 on your legal education, you get to say treble damages. So there are several states that have these consumer protection laws, and you'll see them in unfair trade practices laws also, that provide for these trebling of damages. And what they're really trying to do is incentivize, unfortunately, plaintiffs' lawyers to bring these cases and essentially act as private attorney generals. So they'll bring these cases and essentially the trebling of the damages. So you go from $51 million to $153 million. That additional $102 million is essentially a fine or a penalty, and that hanging out there, hopefully is encouraging people to do things the right way. But again, that's going to be a state statute and probably more than half the states have statutes that will provide for those types of trebling damages in certain situations.
So now this seems like a lot of money. Let's bring it down to where most of our attendees are, where they're investing maybe $1 million, $1.5 million of a client's money. They get in a lawsuit. That could be tripled as well. I don't have a law degree, so I'm going to say triple, okay?
Okay, no, that's fair. That's good. Follow the rules.
All right. So they can be tripled as well, right?
Absolutely. And in some of these statutes, you're into a situation where some of those damages are not going to be insurable. They're not going to be covered by your insurance when you start getting statutory damages applied to you. So another thing to be cognizant of.
Well, I'm going to be painting a little dark picture here, and then after I paint the dark picture, it's going to get a little bit better here. Blake Harper, attorney for 3 basketball players, said his clients lost $5 million from this guy, but another attorney then joined the suit and said, hey, my clients lost $7.6 million. Now, the reason we have these first ones here is just to give you an idea of how sometimes these cases can become just a huge amount of money, and E&O coverage probably is not going to protect you. Now we'll get into a little bit different situation here. And I brought this one on, I just went to the internet with these. I did pull 2 down intentionally. I pulled this one down because I know Don Dewey, and he was a superstar advisor. He personally, in his own personal production, did $12 to $14 million in personal production per year. But in 2008 hit, and he had a lot of partnerships, limited partnerships that went under. And so here, after putting all that money away, the court, who could have went for a lot more money, settled for a $3 million settlement because, according to Dewey's attorney, he only had assets of $1.9 million. So here's someone who is, I know personally, attended a lot of the seminars that I gave personally, knew him well. His office building, you can see from my office building, is $14.5 million vacant office building. Can be seen, is very close to where I am right now. And this becomes pretty personal to me that even the E&O coverage didn't take care of all of his needs.
Well, we'll come to this at the end, but let's hope that Don had a good fourth wall, and what they're talking about in the 1.9 is what he didn't have behind that wall.
I am very suspicious that he did have a good fourth wall because I know the attorney that worked with him very well. He's out of Columbia, Missouri. Here's Illinois State Attorney General filed a lawsuit Thursday against Richard Lee Van Dyke and his financial firm, Dick Van Dyke Financial. Now, I personally think anyone that would name their firm Dick Van Dyke Financial probably is a little iffy to begin with. But the Attorney General filed a lawsuit against him, and court documents stated that Van Dyke earned $160,000 for 31 transitions, but his clients lost $263,000. So if you look at this, right at the top, Illinois sham agent on index annuity sales. So here were someone doing index annuity sales, and look what they went after him for. At the same time, Illinois insurance director moved to revoke Van Dyke's insurance license based on the Attorney General's complaint. So, David, I'd like you to address, even before he was convicted, or anyone would, or he was convicted at all, the Illinois insurance commissioners that pulled his insurance license. Would you like to elaborate on that a little bit?
Yeah, I mean, let's all keep in mind that you could get your license pulled without being indicted to start with. So here the Attorney General has taken the step of indicting them, and those criminal prosecutions are subject to a burden of proof before they're brought as a criminal complaint. So this doesn't surprise me at all that your license is going to be subject to forfeiture, even before criminal action begins.
So as we look at this, what did he do wrong? And I picked this one intentionally because of what they claimed he did wrong. The Attorney General's lawsuit contended that Van Dyke falsely advertised and misrepresented to seniors. Now, once again, if we're dealing with seniors, it's a higher standard that prosecutors and the Attorney General and the state insurance commissioners and the courts are going to hold you to. Advertised, misrepresented to seniors that he, quote, acts as an objective, knowledgeable, and unbiased financial expert to help them make sound choices in investing their retirement savings.
Yeah, I mean, there's all kinds of things wrong there. I mean, financial experts scares me, assuming insurance license only. Investing as a word scares me, again, assuming that he's insurance license only, which I believe he was. So he was not on sound ground to start with.
So just a couple more here. This one is really interesting. Here's an agent that is facing burglary charges. Let's see what he did. He is accused of selling a fixed index annuity with a surrender charge. Specifically, the prosecutor alleged that Lewis, the agent, induced 12 seniors, just 12, into surrendering individual retirement accounts or annuities for a less favorable annuity, according to the court documents. The clients incurred a surrender charge that Lewis promised would be offset by the bonus of a replacement annuity. What is wrong so far with this picture, David, that you could do?
Well, the bonus obviously only goes to the income, so he's not making up for the surrender charge in cash. But this will be a good one on that point. This will, when we're talking about communicating back to your clients, because perhaps he explained that. Perhaps he explained that it was income. We don't see them quoting any of his communications with them. But if he didn't document that communication where he's explaining the difference between their actual asset base and their income base, he opens himself up to these kind of claims.
Well, he even said the defendant Lewis was aware that the bonus was elusive, it was on the income, but misrepresented the same to the victims according to a preliminary hearing. In any event, in the mere 3 years after replacing the last annuity, defendant would return to the annuitant and persuade him or her by false pretenses to replace the annuity again, and once again using that bonus scenario. So as a result of this, the brief alleged Lewis was twisting and caused seniors to lose more than $300,000 in surrender penalties. He was charged with 36 felony counts of willfully embezzling an elder for an amount exceeding $950, grand theft, in excess of $400, and burglary. Prosecutor argued that the surrender penalties constituted embezzlement and theft, and because Lewis did some of the transactions at the client's homes, he also committed burglary. Boy, this seems pretty serious, David.
Oh, it's definitely serious. They stack these claims. It's really the criminal equivalent or the analog to the CPA suing you for $180,000. I mean, what they're trying to get to here is a plea bargain, and the more that they can stack on, and the more penalties and possibly jail time facing, the more likely they are to get them into a plea bargain that they like.
So one last one, and this one is pretty famous. This is Glenn Neeson, independent insurance agent, and he is ordered to spend 90 days in jail on felony theft conviction for selling a complex annuity as an equity index annuity to an 83-year-old woman who prosecutors allege had shown signs of dementia. And you're familiar with this. It's my understanding that this was appealed.
Well, that's right, Rex. I mean, the rest of the story is he did appeal it to the California Court of Appeals. He did get this conviction overturned. The state took that up to the state Supreme Court, and the reversal of the conviction was upheld. So he got out of this felony theft conviction but by then his license had been revoked back at the time of the original trial. He got that reinstated a couple years later, but by then he literally was homeless, was living with his in-laws, was family off of food stamps, had declared bankruptcy, and given the notoriety of this case, I'd be shocked if he's ever able to rebuild his practice. So the damage had long since been done.
So, the court said that he was innocent, but that didn't help. It destroyed his life. Now, I want to point out two things. And the two things I do want to point out is that the 83-year-old woman was brought to Mr. Neesham by the woman's quote-unquote boyfriend, who was a client of Glenn's. And as a result of that, when they filled out the paperwork, she did not name her family or her children as the death beneficiaries of this policy. She named the boyfriend. Number one, that would, threw up some red flags. And when they went to the bank to get the money to put into the annuity, the woman at the teller felt that she was suffering from dementia and actually called Mr. Neesham's office and said, I don't think you should put this woman into an investment. I feel that she has dementia. So he was warned ahead of time that people felt she had dementia, and who got was named as the death beneficiary was her boyfriend. So is it any wonder, David, that the children pursued this through the state insurance division?
No, and it's not at all, and I suspect that he was probably facing some civil litigation. So, and I mean, a couple interesting things to point out there. I mean, even with facts, he got out of the criminal prosecution, but again, he was facing plenty of other problems, and certainly sort of paid for his actions. But the other thing, and I'd like to come back and kind of touch on this case as we walk through, kind of know your clients, and again, documenting your communications. But the thing that I focus on when I'm talking about this case is the difference between an advisor who's looking to make a quick buck or looking to build a long-term business. Because the more that you focus on the former, the more that you focus on one transaction or one commission, the more likely you are to end up in these kind of problems versus building a long-term practice that will sustain you for the rest of your life.
So that's all the negative stuff. So now let's get to the good stuff. And the good stuff here is how we build our 4 walls of litigation protection. The first wall, the first line of defense with our clients is knowing your clients, being familiar with your clients, understanding your clients. That is our first wall that we always use to protect ourselves from litigation. Number 2 is doing the right thing and being able to prove it. I don't think anyone who's been to one of my ATEs has not heard me say this. It is not important to do the right thing. It's important to do the right thing and be able to prove you did the right thing. So that's our second wall. Our third wall is having proper E&O protection, and we're going to talk a little bit about E&O coverage, which might surprise a few of you. You might not have the E&O you think you have. And then the fourth wall is how you own your family assets. Now, basically, just so you understand, what we're talking about is protecting our practice, but also helping our clients protect theirs as well. We've worked long and hard. All of us have put a lot of time in to building a practice that is worth value. We put away money in our retirement accounts and savings, and we have other assets, and we want to protect our family assets against litigation, and we're going to use these 4 walls to help protect our assets if we are faced with litigation. So the first wall of defense is knowing your client. And if any of you are on here that are securities licensed, we know knowing your client, this is part of FINRA rule. You need the legal name, address, citizenship, they have to be suitable. The advisor must have a reasonable basis so that a recommendation for a client is suitable for that client based upon information obtained through reasonable diligence. They're expecting us to do the diligence to dig into the client's situation and obtain that information from the client. Know their investment history. How experienced are they in investing? What is their time horizon? Are they going to need the money in 20 years or are they going to need it in 2 years? Disclosure of the risks, the market risk, the liquidity risk, inflation risk, business risk. What it means is, I just told you the FINRA rules. It really means knowing your client really, really well. Ask questions. Listen, ask more questions, listen, then listen some more. I have been with people, I used to do a lot of joint casework. And when I would go out and do joint casework with other advisors, I was so amazed on how much they just talked about themselves all the time. The client meeting is not about us, it's about them. Don't bother telling the clients what a great advisor you are. They already think you're competent, or they wouldn't even be meeting with you to begin with. So they're coming in, they're meeting with you, or they've accepted a client, you're meeting with them in their home or place of business. They wouldn't have invited you there if they didn't think you knew what you were talking about. If they are leading another advisor, find out why. And David, can you grab the football on this one, because I think you might have some insight here on why this is important.
Yeah, I mean, this, just going back to 20 years of private practice of law, I mean, this was absolutely part of what we called our client's intake. So we would always find out, and I did litigation, so it was either the beginning of the case or they were leaving an attorney to come to us. So I would always find out why. Why happy? Why weren't they satisfied? What was their billing history? And we would often take the next step of calling that former attorney and finding out what it was from their perspective. What was that client like to work with? Did that client ever threaten to sue them? Did that client ever sue them? This is a really good one for really digging into, not so much, this one's really all about protecting yourself more than helping the clients or furthering that business relationship. Of, what's that client's history? What are they like? I guarantee you that a client that has sued an advisor in the past is much, much, much more likely to sue one in the future. And so, you just want to have your eyes open if you're going to go into business with that person, or if they've just, historically been unhappy and burned through advisors every 2 years, you're going to have a real hard time pleasing them.
One of the things that we have found is get them talking about their children, their children's marriages, and their grandkids. All clients love to talk about their family, and they may not be real happy with their children, but they love all of their grandkids. So find out if there's any troublemakers in the lineal family tree. This could be a spouse of one of their children. Find out what is important to them. I've used this when I've run into a wall and I'm not getting them to be able to talk. I'd say, if you were giving $1 million with the stipulation that you must give it away, but not to a friend or relative to whom you would give it, that really gets them thinking, and all of a sudden you find out what is important to them. The American Cancer Society, the Heart Foundation, and if you say, okay, why are you want to give this money to the Heart Foundation? And they say, well, my mom and dad died early of a heart attack, and 3 of my siblings have had heart attacks, and 2 of them are dead. Then that tells you a lot on how you should be investing their money and working with that client. Again, listen and take really good notes. Keep all of your notes and document. And the question is how many years? With our broker-dealer, they say you have to keep it for 7 years. I talked to, David, I haven't talked to you about this, but I talked to a securities litigation attorney, and I said, how long should you keep papers? I mean, how long is it that someone can still sue you? And she responded, and really surprised me. She said discovery plus 6 years. In other words, what she was saying was, when the error or omission was discovered, and then 6 years after that. Well, couldn't it be the children that made the discovery 10 or 12, 15 years from now?
Absolutely. And I always like to state what I think is the obvious, that a lot of what we talk about, there is a balance between the litigation protection aspect and the practicalities of how you run your life. 20 years ago, keeping documentation for 15 or 20 years, depending on how active your practice is, could be a huge burden. I mean, you may not have enough space in your office to do that, and you're looking at off-site space, and then you're looking at keeping that up and actually keeping it organized so that you could find it. These days, that burden is significantly decreased just from a paperless perspective. It's much easier to keep mass quantities of information, and frankly, it's much easier to keep it organized. So to the extent that you haven't gone paperless in this regard, consider that as a way of moving your practice, because it's just not that hard anymore.
Yeah, we're paperless here, and one of the things when we meet, even with our existing clients, when we meet with an existing client and Karen's there taking the notes, the first thing she does when they walk out the door is she goes over and she scans it in, and it's in their file, and she actually then shreds her notes because she now has them in the file, and it's just that simple.
Perfect.
Introduce a data collector. Can be filled out before your appointment, can be filled out during your appointment. It's a great source for asking questions. Do you think it's important to have a data collector, David?
I think it's a great resource, and the other point I like to make when I'm talking about litigation protection is that almost everything we do from a litigation protection perspective can be equally valuable from a building your business perspective, and I think this is a good example of that. From the client's perspective, if you come in and you're organized and you've got a data collector and you spend the time going through it with them and you're interested in them and you're interested in their kids and grandchildren, I mean, that is a great start to that relationship, and that is a great impression that you're making on those people about who you are as a person and who you are as a professional. So this is not just about protecting yourself. It really is about building your business also.
Well, we found what we felt was a good data collector online, and so at the end, if you don't have a data collector or you want to possibly look at changing your data collector, we felt this one was really good. And Brian will send you the URL at the end of the webinar today. And if this is something you need or you'd like to look at, you just hit that URL and it'll be right in front of you. And finally, choose your clients carefully. I think some of the best business decisions I made when I was actively recruiting clients was the clients that we did not accept. And I would assume it's the same way with law practice. Is there a correlation there, David?
Oh, there's no question. And I'll tell you what, I think from any professional's perspective, when you get to the point in your practice where you can turn away a potential client just because it's not someone you want to work with, because it's someone that you understand that the risk probably outweighs the reward, that's a great place to be as a professional, and just mentally will make you happier in what you're doing.
So we want the clients to have a solid trust in you and your practice, and we have to earn their trust. Just because we're insurance licensed or securities licensed, that doesn't mean we know what they are doing. We can say this about anything. I mean, just because someone has a law degree doesn't mean that they're a good attorney. So we have to earn their trust, as doctors and all professionals need to do. One of the rules that we try to live by here is we want to under-promise and over-deliver. And as long as we're under-promising and over-delivering, we have not had a problem. But whenever I've seen advisors, and as I said, I did a lot of joint case work, they scare the daylights out of me because they would be quoting rates of returns and things that a trust would do and wouldn't do that was way over-promising, and I knew that they were going to get under-delivered, and they wouldn't. And as a result of that, I would often stop working with them. I want to talk about this one, David, because this is so easy. The number one reason clients leave their advisors is that they don't return their phone calls quickly.
This is another one that's very analogous to the practice of law, and this was at my 450-person law firm. I mean, this was part of our culture, was to return phone calls within 4 hours. And I would advise you to adopt that in your practice, because it amazed me as I was building my practice at how easy other lawyers made it by simply communicating with their clients. And from a litigation protection perspective, and again, there's this duality from a building your practice and protecting yourself against litigation. Clients that are happy with you are much less likely to sue you. And if you can start with that, just being happy with the way that you practice and the way that you communicate with them and the way that you show them respect in that communication will overcome, or at least can overcome, the occasional hiccup in whatever recommendation you've made.
Make every client feel as if they are the most important client. This is just one thing that my wife started doing a number of years ago, is we stopped sending out Christmas cards. Whenever we'd send out Christmas cards to our clients, even if she wrote a little message on it, it got mixed in with the other 100, 150 Christmas cards the clients received. So what she would do is, and she still does to this day, is with our clients, she sends them out an anniversary card with a message on it. And the reason it sticks out is that virtually no one sends out anniversary cards. And so at most, she's one of three and probably the only one. And to receive a phone call the next day and saying, I can't believe you remembered our anniversary. One other thing that just, you talk about locking in a client, and that is anytime a family member passes away, we purchase a Christmas tree ornament with that client, the decedent's name on there. So if the husband passed away, we would personally give to the wife a Christmas tree ornament that has their name, the husband's name on it. And the response of people saying, every year when I put that ornament on the tree, I get a tear in my eye and I think of you. So there's so many little things that we can do for our clients. We may need to feel confident that we can also trust our clients. We don't want to get in with clients that we can't trust, and clients don't want to work with us if they can't trust us. And do not accept someone as client solely based on their asset base. Just because they're wealthy doesn't mean they would make a good client, as Glenn Neesham found out earlier. And every client, and David, you said this, and I'll repeat it, every client represents potential income and liability. So you have to look and say, is the potential gain worth the liability? Is the risk worth the liability? So these are questions we need to ask. So that's the first wall. That's the first wall of defense coming in, and number two is doing the right thing and being able to prove it without saying always do what is in your client's best interest. And doing what's in your client's best interest may not be making the sale or as big a sale, but do what is in the client's best interest. You may be tempted to oversell a client in order to make this month's mortgage payment, but how much commission fees can you generate when you're consumed for 6 months in litigation? And I'm being a little optimistic there, aren't I, David?
Oh, absolutely. I mean, probably 2 years or 3 years and hundreds of thousands of dollars these days.
Just to make a mortgage payment. And once again, I want to look back on Glenn Neesham, because most of us know that case. And even though he was quote-unquote right, what it cost him. Never sell an investment or service to a client not completely understand what you're presenting. You know, equity index annuities, variable annuities, they are complex. And it takes more time than the average investment to make sure that the clients understand what they're talking about. Make sure they're understanding when we're talking about the bonus, we're talking about the roll-up, that this is on the income base, not on the asset base. And make sure they understand that completely. Danger signs. illiquidity, especially the older a client is, the more liquidity they're going to need, and they're going to be expect you to give them. And I'm talking about the insurance division of your state or in litigation. If they're confused at all, if they seem to be confused, what we do, if they're confused, that's when we bring in other family members, and usually children. Because the ones who oftentimes are going to end up suing you, and this is going to be a point later, is not the client, but it's the children. Early signs of dementia. If there's can't remember your name and can't follow along with you, that is a real danger sign, as once again Glenn Neesham found out. Prove that you did the right thing. Take copious notes at your meetings. One of the things that I was very fortunate, I'm a very poor note taker. Fortunately, I married someone who was a very good note taker. So all through the 30 years of being in business, one of the things that we always did is I did most of the talking, surprise, surprise, and my wife took notes. And whatever was said, she just copied it down word for word. As much as she could, and even with our clients today, she still does the same thing. Once again, after a meeting, she goes out, scans it, and it's put in their electronic file. Send a written summary of your meetings, and David, I want you to elaborate on this. Send a written summary of your meeting to your clients detailing what you discussed. Include what actions are to be taken, who's responsible for what actions, and why it is agreed upon that these actions are needed. Include what investment choices were made, why these investment choices align with the client's stated goals, investment timeline, family circumstances, risk profile, and income needs, and include a paragraph which asks the client to respond in writing if anything in the letter is inaccurate. And so as a defense attorney, would you like to see your client have this if someone is accusing them of something?
Well, I'm going to switch the order and talk first about building your practice. I mean, again, just think about this from the client's perspective, getting this back after a meeting with you, after you asking them a lot of questions, getting to know them, hopefully them having a good feeling about you. But then to get a communication like this back that shows that you listened to them, that you understood, that you gave this some thought, that you're have this detailed attention in your practice and follow-up, again, I think goes a long ways towards building that relationship. From the defense lawyer perspective, I would love to have this document, and too often you don't, and then it's a swearing contest. It's he said, she said. And I like to say that, as soon as you get to that point, you've lost because you're now involved in that litigation. Your license is at risk. Your practice is at risk. So to take this step, and I mean, the third point is I think that oftentimes that follow-up piece of writing is a really important communication. It's one thing to sit there at the kitchen table and kind of talk about everything orally, but studies have shown for the last 20 years that different people learn and interpret and really understand information differently. So some people it's oral, some people it's writing, some people it's pictures or videos. So to hit them with this second piece of communication in a different format, I think is terrific and would be super helpful. And if you go back to the Glenn Neesham, one, he should have gone and talked to the kids. But if he explained this all back to her in an email, and why you're naming your boyfriend as the beneficiary, and this is what you explained to me, and is there any issue, that would have been helpful. May not have gotten him around the dementia piece, but it clearly would have been a lot better than having nothing.
If your client is doing something which you disagree in, withdrawing too much money, taking too much risk, failing to diversify, express your concerns in a document in writing. It's their money. They can do what they want to, but make sure they understand, and you can prove if their actions are in opposition to your advice.
Yeah,
now,
and Rex, let me jump in. So this is another one that's completely analogous to the practice of law, and this, all you're getting paid for as a lawyer is your advice. And so when you have that conversation with the client and you explain to him the risk of what he's doing and that you're not advising him to do that, and he says, I understand all of that, thank you, I'm going to go ahead and do it anyways, then you're going to help him do it the best way that he can. But, you know, I would always send that follow-up email. It's so easy these days, just saying, hey, just, you know, one more time as we discussed, blah, blah, you know, here are the risks. You want to go ahead and do it anyways. You know, we're going to make the best of it. And, you know, so often you'd get the back and you'd be like, yeah, you know what, now that I think about it, you know, I'm not going to do that. So this is again, it's great communications, doing the right thing for your client, but it's also protecting your
what we do is we type out what, you know, Karen goes in on the computer, she'll type it out, have them sign it and date it, for instance, if they're taking too much money out, and then we blame it on the broker-dealer. We say, you know, our broker-dealer makes us do this. They want to have it documented that we did tell you that we think you're taking too much money out in order to have sustainable income for life. If you aren't securities licensed, you blame it on the insurance company, and I'm sure the insurance company would like to have you document all of this. And remember, your clients may love you, but their children may be the ones who take actions against mom and dad's financial advisor when they do not receive the inheritance they are expecting. They weren't at these meetings. They don't know what went on. So if we have it in writing, that's the key. And as David said, then it's just your word against theirs, and oftentimes you're going to lose in a situation like that. Also have a full disclosure disclosure form, and then have them sign and date a duplicate form for your records. This is an example disclosure form, and Brian and I were chuckling. Brian is sitting across from me right now. His first job out of college was he came to work for me, and we pretty much have been together ever since then. He hates it most of the time, but he's still stuck in there. And we were talking about, remember when we first made this form, and that had to be 20, 25 years ago. But this is just one paragraph. And we're disclosing, while the information contained in this analysis is from sources believed to be reliable, some information and projections may be affected by changes in laws, tax rates, interest rates, investment rates of return, inflation rates, deflation rates, and other factors beyond our control or influence. For that reason, the accuracy and completeness of such information and any projections and opinions based thereon are not guaranteed, but are to be construed as what might be expected to happen if all projections, assumptions, and informations are found to be accurate. So this is part of our disclosure form that we have for every client. The other thing before I get off this subject is we never ever, when we gave them a plan, did we ever call it a financial plan. Because if you say a financial plan, that's assuming you're covering all of their finances, their disability insurance, their life insurance, their long-term care insurance, their loan at the bank, I mean, everything. So we always named ours a specific objective financial analysis. So everything was a specific objective. It would, and we put on in the as well that this is not a financial plan. So we're going to go ahead and send this to you. You can read our disclosure. If you like anything on it, feel free to copy it and use it yourself, or look at it and throw it away, whatever you want to do. But that's going to be sent out to you as well. Have them fill out and sign a completed risk profile form. Our broker-dealer makes us every year, with every client we have, complete a risk profile form, and it's for our protection and the broker-dealer's protection, and also to understand our client. Their risk profile may change. This is an example risk profile. This is one that we made up in our office. Once again, feel free to use this if you want to, because we're going to go ahead and make it available to you at the end of the webinar today for you to use. So our first wall was know your client. The second wall was do the right thing and be able to prove it. Now let's assume a client broke through those two walls. Now you're faced with possibly an E&O claim. So looking at your E&O coverage, what to look for, per individual claim is often no more than $1 million. And David, after the next point, I'm going to have you come in and talk about this. And often aggregate or total claims involving this particular investment or situation, aggregate of $2 million. What do you? This is from the source that I received. Looked up. They said this was about average. What do you think about that?
In my experience, it is about average, and it's usually the minimum required by most of the insurance carriers whose contracts I've looked at. And there's a couple interesting things to note here. One is that increasing your maximum coverage is usually not that expensive. So I would encourage people to at least take a look at it and see what it costs and then make a business decision from there. The other, the sort of countervailing point, though, is that similar to settling for defense costs or attorney, it's not uncommon. So that's sort of a defense motivation to pay up to that amount. The flip side is that from the plaintiff side, it's not uncommon to reach lower settlements when they're the maximum of the insurance coverage. So if you've got a $1 million max, it's not uncommon to be able to settle a larger claim for that cap. Whereas if you had $2 or $3 million, they may want more of that. They may want 1.5 or go up to that new higher cap. So a lot of times having less insurance promotes settlements at a lower dollar amount, but increasing those maximums oftentimes is not that expensive and gives you a little bit more peace of mind.
Deductible is often $25,000 and can increase with each claim. With some E&O companies, it's one strike and you're out. This really came home to me probably about 10 years ago now. I decided I was going to start an investment advisory company. My wife was going to do the securities. I was going to do the investment advisory. I lined everything up, and one of the things in my due diligence was I looked at the E&O insurance. And so I got a hold of several E&O companies, and they said, fine, well, we'll write you there, no problem there. And I said, well, if I have a claim, how many claims can I have? And they said, if you have one claim with us, we'll probably not renew your contract. And then what I then asked and said, well, wait a second, how easy it is for me if I have a claim to get coverage with another E&O carrier, and they said it was pretty hard to get. So one of the things when Karen and I were looking for a broker-dealer, we wanted to have a broker-dealer that had at least the 3 strikes and out. So with our broker-dealer, they have the 3 strikes and you out. Number one, the per claim is a lot higher than $1 million. The aggregate's a lot higher than $2 million, and we're both paying E&O, so that's doubled there. But it generally does not cover any activity outside the core business, such as the practice of law. If you're recommending to clients, you need to have a life insurance trust. You need to have a charitable remainder trust to solve your tax situation. That can be interpreted as practicing law. And do you see a problem there as far as your E&O coverage, David?
Yeah, and it's really not limited to the practice of law. That's probably the easiest example. But anything that gets outside of, and again, if you're insurance license only, it could be investment advice, obviously. But yeah, I mean, a huge risk, and it's probably not doing the right thing by your clients anyways. If you're not an expert in that area. And again, flipping it around to the business development side or building your practice side, if you don't have a referral relationship with a good trust and estates attorney, for example, that ought to be something that you're looking to develop. It's a great resource for your client, and then it can be a great source of business for you coming back from the attorney.
The other thing I looked at when we looked at our broker-dealer, we wanted to make sure our E&O policy had a tail. And what a lot of E&O policies do is they cover you as long as you're in business. Then when you stop business, 10 years later, you're on the beach drinking out of a glass that has an umbrella in it, and someone hands you a subpoena, and you find out someone's suing you and you don't have any E&O coverage. Make sure that your E&O has a tail. After you stop doing business and you're no longer in the industry anymore, will it still take care of these cases that you developed when you were in business with them? And also, if you're changing E&O carriers, if you can, try and find one that will cover prior acts that you don't know about. Obviously, they will cover prior acts that you know someone's coming after you. This is what to look for in an E&O coverage. And once again, generally the E&O carrier generally will settle, and it will go on your record, even though you may not have done anything wrong, such as I did with the CPA in that tax shelter. Finally, I want to talk about the fourth wall of defense. The first wall, once again, was knowing your client, knowing them very well. Second wall was doing the right thing and being able to prove it. Now, the E&O coverage, it's come in over the E&O coverage, much like Don DeWay in his example earlier. So keep the work and family assets separate. Even if you have your business set up in an entity such as an LLC or a family limited partnership or a corporation, don't expect that document to save your family assets, because usually they're going to go after the entity as well as the person that actually made the sale. Would you agree, David?
Yeah, they definitely are. In this line of business, you're pretty much always going to be on the hook personally in addition to your entity. So that's not going to be it's not going to be a great line of defense. It is something, and it is something that you can argue, but I definitely would not be relying on it.
Some assets are protected from most creditors simply by owning them. Number one I want to talk about is qualified accounts. Patterson versus Shoemate. That is for qualified plans, and I know we often call IRAs qualified plans, but they aren't. Qualified plan is anything out of Section 401 of the Internal Revenue Code, and IRAs are not found there. IRAs are technically a tax-deferred vehicle, even though it's tax-deductible if it's a traditional IRA. So qualified accounts are protected by a court case. IRAs are protected from bankruptcy thanks to the Bankruptcy Abuse Prevention and Consumer Protection Act, and that is a mouthful. Contributory and Roth IRA assets are capped at an inflation adjusted of $1 million, and that's currently up to $1.25 million. But don't let that scare you, because rollover IRAs are exempt from bankruptcy beyond that limit. So let's assume you have a client that has $4 million with you, and $3.5 million of that is a rollover from a 401k, and $500,000 is contributory. Then you're covered. You're covered because the $500,000 is below the $1.25 million limit, and the rest of it is rollover money, and that has no limit on it. This act also protects SEPs and simples because they are also IRAs, as well as coverall savings and 529 plans. So all of this comes under the Bankruptcy Abuse Prevention and Consumer Protection Act that was passed back in 2005. Some assets are protected from most creditors just by simply owning them. You have state exemptions. Now, in the states, qualified plans and IRAs are either protected by the state bankruptcy laws as well, anywhere from 100% down to what is reasonably necessary for support. Homestead exemption, your house 100% exempt down to, in some states, $10,000 in value. Life insurance cash value, 100% of the cash value is protected down to none of the cash value protected. Annuity cash value from 100% down to, in some states, none. Now, why did O.J. Simpson move from California to Florida? Well, number one, Florida exempt for qualified plans is 100%, but what he took with him was $3 million, and that $3 million he took with him to Florida was the amount that the Brown family could not get because it was in a qualified plan and it was protected by the Supreme Court case. Also, he lost his house in California because a home is not totally protected in California. In Florida, 100% of your home plus up to 160 acres of land is protected. So a great state to go to if you're trying to avoid your creditors. Exemption for annuity cash value, either variable or fixed annuities, 100% for the owner as well as the beneficiary. And Now, how do we know this? There's a great website that I found that has every state's state exemptions in qualified plans, in homestead, in life insurance, and annuity cash value. And so you click on this, it'll take URL, it'll take you to the site, and you can find out what the exemptions are for your state versus all the other states. In some states, assets are protected from most creditors by how you own them, owned by a non-litigated spouse. So, my wife and I aren't, we can't benefit from this because we're both in the practice together, so we're both going to be sued. But sometimes just by having your assets in a spouse, so if you have a spouse that is a school teacher and you are in the investment industry, maybe an easy way is to have the school teacher spouse own the assets. There's some states like Wyoming.
Just stating the obvious again. The risk there obviously is that at some point you stop getting along with your spouse. So most of this stuff, I mean, there is a sort of a pro and a con. And you need to keep the big picture in mind.
Some states like Wyoming, tenants by the entirety, which means you can't break up an asset owned by tenancy by the entirety, so you'd actually have to sue both spouses or have a legal claim against both spouses. Corporation can be used as asset protection, a limited partnership, often a family limited partnership, a limited liability company, and it can be a one-member LLC, a charitable remainder trust. Then we're going to get, I started with the easiest stuff, started getting a little more complex. Now when you start about special asset protection trusts and offshore trusts, we're talking about someone who has a lot of assets. Am I right, David?
Yeah, these are expensive both to set up and maintain, so you need to have a pretty significant amount of to even make it worthwhile.
Avoid joint accounts even with your spouse, because if either spouse gets sued, it can make both of the asset or all of the assets be accessible to a creditor. Partnerships, and I won't get into it because we're running a little bit behind and we want David to answer your questions. Being on a board of directors, if you don't understand that one, send Annexus an email and say, get this to Rex and ask him to explain that situation here. So I want to end the main part of this, our fourth wall. I'm going to show you not what my wife and I set up a year ago, 5 years ago, but we started doing this 20 years ago. And so here's our business, and you can see our financial planning business, and it's in red, which means danger here, because we do all the investing. Actually, my wife does all the investing, but we work together. It's our business together. Even though mainly I work for Annexus, we're both going to get sued. So our trails, our renewals are exposed to a creditor. I haven't thought of a way to get around that. We both have our own living trust, but which does nothing, but Karen has IRAs, I have IRAs, I also have a profit sharing plan. Everything in green it has some creditor protection to it. We have a personal checking and savings accounts, and when I put this together I thought, how big our personal money market account was. Saw it was too big for my comfort, so I moved it, and I'm going to show you where I moved it in a second. In Iowa, you get your homestead plus 40 acres, and so we live on a 150-acre farm, and so as a result of that, I put on a separate deed our homestead and 40 acres, so I chose the 40 acres in case we had litigation, and I wanted to protect that. And then the rest of it, that's Oakland Farms 1, is in a LLC, a limited liability company, which has asset protection with it, which we can't explain now, but this is here so you can understand that you might want to talk to an attorney about any of this. We have a second farm. It's a one-member LLC owned by my wife's trust. And then we have a brokerage account, and that's in Boglin Investments LLC, and that's where I moved that extra money market money when I was putting this together and saying, hey, that's too big. I need to do something with it. We have a leasing company which owns all the furniture and all the computers and artwork on the walls and everything else in our business. So that is protected as well as our farm equipment is owned by the leasing company. And finally, we have a charitable remainder trust, and in that charitable remainder trust, it's protected. So this is our fourth wall. I'm not saying this is what you should do. What I'm saying, this is what we did, and this will give you a taste of what it is to build a fourth wall. If the first wall fails, you want the second wall to hold up. If it doesn't hold up, hopefully the E&O coverage is enough. If that doesn't hold up, you have a fourth wall there. It's too late once you get a notice to start moving assets around. And David, this is right down your alley, so I'm going to let you handle the fraudulent conveyance and transfer.
Yeah, there's a couple different ways to look at fraudulent transfers on the screen. The first is really in the bankruptcy context. So anything made within a year with intent to defraud or deny a creditor access to those funds is going to be a fraudulent transfer and is going to be accessible wherever it ended up to that creditor. So a 90-day clawback, so anything that gets transferred, regardless of the intent, 90 days before filing for bankruptcy is going to be subject to getting clawed back into that bankruptcy estate. The second is a little bit broader, and that's any transfer you make for not reasonably equivalent value. So that's when you sell your house to your cousin for $10. If it's done at a time where you're either insolvent or it makes you insolvent, and you're unable to pay your debts, all of these, and it's one thing to do any of this again, long before you file for bankruptcy or long before you've got a creditor making a claim. But once you're on notice of that claim, whether you've gotten a letter or whether you even know, something went bad that could lead to litigation, that's when you're really in the danger zone and you need to be cautious about how you're treating your assets.
So when is the best time to plant a tree? The best time to plant a tree is 20 years ago. The second best time to plant a tree is now. And the reason we showed you the fourth wall, when is the best time to build your fourth wall? 20 years ago. When's the second best time? Right now. And so you may want to look at different ways that you could protect your assets that you have in order to protect your family and your family's assets. I have a fire extinguisher in my home, and I tell you, I hope to never use it, but I sleep really well knowing that I have that big fire extinguisher in my home. I hope to never use my fourth wall, but I sleep really well knowing that I have that fourth wall there. So there are the four walls, and we want to get into dig inside your brain a little bit. So we have a few questions here for you, David. Are you ready to take some questions?
I am, but let me make one more comment on the fourth wall. Don't get intimidated by what Rex has done. It doesn't have to be a do 100% of it today. All of this stuff can be done incrementally. You can take one step at a time and add on to it as you go. And then the other thing is, like most of the things we've talked about, they're sort of the pros and the cons. Of adding that complexity to that fourth wall is you're adding protection. The con, a lot of times is expense, and a lot of times the expense of maintaining it, because you've got to pay attention to exactly how you're treating those assets and where they're flowing and how they're titled as you continue to add complexity to that fourth wall. But so don't get intimidated, get started, but understand that there may come a point of diminishing returns. And with that, go ahead, Rex.
Okay, Larry asks, if you are selling, or if one is selling fixed index annuities, what should that person be afraid of? Well, it is a great question, and it's an interesting area right now because as the industry
exploding might be too strong, but growing extremely quickly. It's gaining, attention first from the regulators, and then usually after the regulators' attention comes, the plaintiff's attorney's attention comes. So I would be cautious. I would take everything that we've talked about for the last hour to heart, and I would be just cautious on how you're portraying the investment and portraying yourself. So avoid the word investment like I just used. Financial advisor, investment expert, avoid all that. And then under promise and over deliver. And probably the hottest thing right now is illustrations. Be really careful about what your illustration is showing and how you're using it. We're in a little bit of an illustration war right now with everybody trying to show, theoretically the best that their FIA could ever do. That's okay if they're getting by with it and the carrier's behind it, but you're the person at the point of sale. Be careful about how you explain that, and I would urge you to say that that is a theoretical best the product could ever do. You should look at that as, if you hit 4 home runs in a row, you might get to that, and down here is the guarantee. That's the worst it could do. Your realistic expectations should be somewhere in the middle. Keep bringing them back to reality, and that'll help you avoid problems down the line.
David, Matt from Virginia says, at what age is someone considered a senior? You said seniors are held to a higher standard.
Yeah, that's going to vary. All of that elder abuse protection law is all state-based, so that's going to vary state by state. I think in Arizona it's 65. I think there's other states where it's as high as 75. So it's going to be somewhere in there, but you're going to want to look at that, based on your state. And that is an area that I predict is going to be continuing to grow in sort of complexity and protection for the elders. Anybody on, from California, they're probably on the bleeding edge of this. But 65 is probably where you need to start paying attention in most states.
David asks, if you tell a client they may wish to talk to an estate attorney about life insurance trust, is that practicing law?
No, any time. It's sort of, to me, it's the same as if you're talking about moving funds out of a VA into an FIA, and that they may want to talk to their investment advisor or professional about it. I think that's great client service and great communication to point them to the appropriate professionals for the appropriate question.
Albert says, I have an insurance license only. What do you think about me selling market-linked certificates of deposit? Would I be covered by E&O coverage? Should I not offer them? If I can jump in here on this, and I will tell you, in every securities exam I think I've ever taken, it says what is not a security, and they have an annuity, and then they have a couple other things in a CD, a certificate of deposit. If you're selling a certificate of deposit, you need a Series 7 license. And I think if you're talking market-linked CDs, I think you're in the gray area only because of the securities exams I've taken. Would you like to comment on that, David?
Yeah, and I can't comment specifically, but I think consistent with what you just said, the real issue is it a registered product? And if it is, you got a lot of problems with trying to sell it. But I'm guessing it's not, or you wouldn't have asked the question, in which case I think you're probably okay. If you're legally able to sell it, your E&O shouldn't be covering you.
Yeah. Phil asks, when handling your client a disclosure letter, how do you present the document to them? Do you find it tough to start a relationship? Well, first of all, I don't do a disclosure letter. I never did do a disclosure letter. The first time we got together, we always did the disclosure letter when we actually presented a specific objective financial analysis to them. And we said, now this analysis is a specific objective, and here are all of our disclosures, and we had them sign that. David, I think we're through most everyone, and normally I really get off right at an hour. I want to thank everyone for staying with us, but we're going to have to move along here. Brian is sending out the promised URLs to everyone right now. Our next ATE is December 4th and 5th, the Annexus Training Experience. I talk on income for 5 hours on Thursday, and then on Friday, Richard Cato is going to be, he doesn't come to all of our events, he's going to be at the next one, though, and he is the inventor of the equity index annuity, and he's going to be presenting. And then Friday afternoon on the 5th, you get to hear from the specialists at Annexus, the owners of the company and the marketing team on the Annexus product, and we are very proud of that product. I want to thank all of you for sticking with us. We had a lot of people on the call today. This is a very important topic. David, I would like to thank you for joining me today.
Thank you for inviting me. I enjoyed it, Rex.
Okay, and I want you to know you're invited every month, by the way. I'm sure you don't have anything better to do. And I want to wish everyone to have a very profitable week. Thank you very much for your attention.
Thank you all.